Hey guys, welcome to my legal classes. I'm your teacher Ganesh Pujari, and today I'm going to help you guys to understand one of the important aspects from the Industrial Dispute Act 1947, that is industry definition under section 2J. This is an independent question. The section 2J, which is discussing about the industry, is a independent long answer question. So actually I can take a 2 hours class on this, but to feed my quick word guys, I am keeping this video as short as possible with the meaning of industry and all the other aspects pertaining to this case. So let's have a quick video on this to ensure that you are getting maximum in a shorter period. Now what I'm going to teach you guys in this session, the first thing is I am going to explain you guys what is section 2J. Then I am going to explain you guys the case laws. Then I am going to share the interesting case which defined industry in Bangalore Water Supply and Sewage Board versus A. Rajappa case. Then I'll explain you guys what is triple test and dominant tests. So these are the major contents I am going to explain you guys in this video. Let's get into the first section, that is 2J. What is an industry? Section 2J defines industry in just 2 sentences. Guys, if it was so easy, it could have been so easy, but unfortunately there are so many case laws which ensure that laws are evolved. So initially in 2J it was defined any business, trade, undertaking, manufacture or calling of employers. Remember these 5 words. It is very important that you bring all these 5 words in your answer. Any business, trade, undertaking, manufacture or calling of employers. You need to by heart this and you have to write this in your exam. And it includes any calling, service, employment, handicraft or industrial occupation or avocation of workman. So avocation is giving the meaning of occupation again, profession. So the entire definition I'll read out once again. Any business, trade, undertaking, manufacture or calling of employers, and includes any calling, service, employment, handicraft or industrial occupation or avocation of workman. This is the definition of industry as per section 2J. Guys, it could have been much easier if it was this much only, but then started the series of cases. So let's start one by one. This act came in the year 1948 and the first case came in the year 1953. I have discussed 5 major case laws initially and the Rajappa case in the last slide. So I have discussed 6 case laws, and let's understand this as a story with different segments what happened when it came to the definition of industry. The first case, municipal corporation case, Dr. Banerjee versus P.R. Mukherjee. The case happened in the year 1953. This is also called as budge and budge municipality case. This happened in West Bengal and Dr. Sen Gupta was the one who has defined industry in this case. You can remember budge and budge municipality case, or if you can remember the name, Banerjee versus Mukherjee, West Bengal 1953, and Dr. Sen Gupta was the one who defined. Now, what was the content here? This is the first time the definition of industry was interpreted. Budge and budge municipality suspended sanitary inspector and head clerk. 2 of the employees are being suspended by this municipality. The workers union had raised dispute demanding reinstatement. Now workers union reached the tribunal demanding the reinstatement. Now in the Supreme Court, the municipality pleaded that it is discharging sovereign function under the West Bengal Municipal Act, and hence it is not industry, and thus the dispute is not an industrial dispute. Because we are doing the sovereign function under the Bengal Municipal Act, we are not an industry, so don't consider us as an industry. That was a request from municipality board. The court observed that the definition is intended to include even those activities that cannot be called trade or business. It is held that municipality is an industry because sanitation and conservation is an undertaking which is comparable to trade and industry. So they defined the word undertakings and used that and told that it is an industry. Whenever you see my slide with green dot in the right corner, that means the court agreed that it is an industry. In the same place, if you see red dot, then the court declined that it is not an industry. So you have to see that picture and understand whether this case said this particular case as an industry or not. In this case, the municipality of West Bengal was agreed by Supreme Court as an industry. Hope that's very clear. This happened in the year 1953. The second came, I am also explaining one case on municipal corporation. This is of Nagpur, Corporation of City of Nagpur versus its employees. I am explaining it because there were 2-3 important aspects came in this judgment, which is saying profit motive is not important to say whether it is an industry or not. And in this judgment, it was held that education department, health department, taxation department, etc. of city corporation are industries. So to that extent, this judgment is very important, which came in the year 1960. So I have brought this case. So that is on municipal corporations. Now let's move on to hospitals. What happened with the hospitals? This is State of Bombay versus Hospital Mazdoor Sabha. This case happened in the year 1960. The 1953 case has said municipal corporation is an industry. Then Nagpur case also held that the municipality is a industry. Now, whether hospitals are industry or not. So this case you can call as Hospital Mazdoor Sabha case. So in this case, the court first time interpreted that hospitals are also industry. Here a workman is retrenched, and for the purpose of compensation, the case came to the court, and the management request was hospital not involved in any trade or business, and hence they are not industry. They said we are not involved in any kind of trade and business, so we are not industry. But the court framed a working principle that any systematic activity for production or distribution of goods or services, remember this, any systematic activity for production or distribution of goods or services done with the help of employees in the manner of a trade business is an industry. The service in the hospital were held to be material service, and hence hospitals are industry under the Industrial Dispute Act. This is how they have interpreted. They brought hospitals under industry in Hospital Mazdoor Sabha case. Hope that's very clear. Then the third question, whether the universities are industry or not. This happened in the year 1963. This was the first case where they said something is not part of industry, that is when it comes to universities. What happened in this case? University of Delhi versus Anwar versus Ramnath versus Ramnath. This is 1963 case. There was a women college run by University of Delhi. So they were giving bus facility for the women working in that university, but due to some loss occurred, they decided to discontinue this facility. And while they were discontinuing this facility, they had to remove this driver by name Ramnath and Asgar. They have discharged 2 of the drivers from the service, and this Ramnath went to the court saying that I need to get retrenchment benefit. So that was the case, and university said we are not a industry. And the court held that the education is important by teachers who are not workmen. Okay, in any institution, education institution, education is imparted by teachers, and teachers are not workmen. The intention of legislature was not to be included educational institution within industry to extend benefits to the drivers and others who are not core service providers. Here what they say, teachers are very important in education institution and they are not workmen, and any other supporting characters, they were not in any kind of core service activity. So educational institutions are not industries. Guys, as of now this stays red, but remember all the reds have become green once Rajappa's case concluded. So you can see this case as red while you are writing in exam, but while concluding your answer you have to mention that all these cases later courts said that these are also industries. But for now, in the year 1963, universities are considered not as an industry. Let's move to hospital. Guys, we have seen hospital already in Hospital Mazdoor case, but there was one more case, Safdarjung Hospital case, where they said hospital is not an industry. This happened in the year 1970. So here what happened? The case reversed the judgment of Hospital Mazdoor Sabha case. Hospital Mazdoor Sabha said hospitals are industry, but this case reversed the judgment saying that hospitals are not the industries. So it was held that a place of treatment of patients run as a department of the government was not an industry because it was a part of the functions of the government Charitable hospitals run by government or even private associations cannot be included in the definition of industry because they have not embarked upon economic activity analogous to trade or business. If hospitals, nursing home or a dispensary is run as a business in a commercial way, there may be element of industry. So what they said, if there is a commercial way the treatment are given, then it can be considered as industry. If it is given as a service oriented, then it is not an industry. That was the plea. So what constitute the services? Material service involve an activity carried on through cooperation between employers and employees to provide the community with the use of something such as electrical power, water, transportation, mail delivery, telephones, etc. are industry. They said the बाकी सब जो भी है वो इंडस्ट्री है, जैसे इलेक्ट्रिक पावर देते हैं, वाटर देते हैं, ट्रांसपोर्टेशन देते हैं, मेल डिलीवरी, telephones, these are all material services. So they can be, but hospital is not that, so it should not be considered as industry. That was the content. Now such material services qualify to be included as services industry, which are that electric power, water, all those stuff. But for professions like doctors, lawyers, teachers, material service do not raise, as they are not engaged in occupation in which employers and employees cooperate. They are saying for doctors, lawyers, teachers and any other profession, it is not an industry. Hence, organizations like hospitals and educational institutions do not fall within the definition of industry. So, education institution is not an industry now. Hospitals, earlier was said that in the Mazdoor Sabha case that hospitals are industry, but here they said hospitals are no more industry. So we are at 1970. Let's see what happened with clubs. This happened with Madras Gymkhana Club. Secretary Madras Gymkhana Club Employees Union versus management of the Gymkhana Club. So in this case, what happened is there is a club in Madras by name Madras Gymkhana Club, and it had about 1200 members, in which 800 were active members. And to serve all these members, when I am saying serve, because there were so many activities were going on like sports, football or rugby or some indoor games, and they used to have parties, dance, singing, celebrations, all such activities were going on. And to manage this, they had about 194 employees, and these 194 employees were not being paid with bonus. Like bonus payment was not agreed by the management. They have not paid the bonus to these employees. So they went to the court, employees went to the court and asked for the bonus, but the court said clubs are not an industry. So your hospitals are not an industry, your educational institutions are not an industry, and your clubs are also not an industry till the time Rajapa's case came. So Rajappa came in the year 1978. You can see Rajappa as Rajinikanth. When Rajinikanth comes, everything changes in movie. Just like that, when Rajappa's case came to court, everything else came to a different scenario. The hospitals, educational institutions, clubs, everything came under the context of this industry. What did happen in Bangalore water supply case? Let's try understand. Here in this case, they have defined for each and every services in a different way. This was argued by V.R. Krishna Iyer, and what he said, hospital, the government department while undertaking welfare activities cannot be said to be engaged in discharging sovereign functions, and hence outside the ambit of section 2J of the Act, same applied to private hospitals too, as it is a systematic activity. Neither government hospitals nor private hospitals can say that they are outside the definition of industry because they are doing systematic activity. So they are industry. That is for hospitals. What is for university? The teaching staff of the university was not held to be workmen, but the non-teaching staff who come within the scope of the set term, so that they are able to take the benefit under the Act. So the universities are also brought into the definition of industry. And for clubs, it is the employees who work for the wage and produce the goods and services, not the club members. So here club members' intention is not important. It is the employees of the club who are serving. When all the services are rendered by hired employees, how can the nature of the activity be described as self-service? That was a question raised, and hence the clubs were also being brought under the definition of industry. Now, why it was so easy to conclude that they all come under the definition of industry. That is because of the triple test. They applied triple test with Rajapa's case, saying that if there are these three tests done and if some industry is passing all these three tests, that will be considered as industry. That was the understanding they came to. What are the triple tests? The first one is there should be systematic activity happening. Second one is there should be cooperation between employer and employee. And the last one is production and distribution of goods and services calculated to satisfy human wants and wishes. So remember these 3 points. 1, there should be systematic activity. 2, cooperation between employer and employee is very much required. And third, production and distribution of goods and services calculated to satisfy human wants and wishes. If any industry passes these 3 requirements, they will be considered as industry. That was the conclusion. See, the dominant nature test was also been taken. Dominant, there should be one N there. If there are complex activities in an enterprise, but the dominant activity comes under the triple test, then the whole undertaking is held as industry. Now somebody says, okay, we are not industry because so and so and so other functions are there. Our focus is that, so we are not coming under industry. In that case, what we have to do? We have to do triple test, and if they are passing this triple test, then they will definitely come under the definition of industry. And the result, after this, what happened? All these professions came under the definition of industry. Remember, the municipality, the hospital, the universities, the clubs, and Rajapa's case made that water supply company board, everything is under industry. Along with that, professions, clubs, educational institutions, cooperatives, research institutes, charitable projects, and other kindred adventures all are coming under the definition of industry if they are passing the ABC test, that is triple test. Now what happened in the year 1982? There was a Amendment Act on Industry. So the definition of industry again being discussed here. I am not explaining the definition again. You can read through it. You can take the screenshot, which is again discussing on few major aspects. There is one major aspect I would like to explain. Any capital has been invested for the purpose of carrying on such activity, and such activity is carried on with the motive to make any gain of profit. So the intention of profit is not important here. So the definition was again realigned in 1982. You can take the screenshot of this, and after that you can also take the screenshot of this. There is a lot of notes that I have given for the purpose of 1982 Amendment Act. Because this is a speed world, if I start explaining all those things, you guys will not even reach my video. So I am keeping it a short video. Please read through these contents. I hope now you are very clear on definition of industry under 2J. You have to remember these important cases: the budge case, the hospital Mazdoor case, Delhi University case, and then the Safdarjung hospital case. After that, you need to remember Gymkhana club case. Then comes Rajappa case. Rajappa case reverses the judgment of Delhi University case, Safdarjung case, and the Gymkhana club case. Remember, they have given triple test in the case of Rajappa's case, and dominant nature test also. If you write this much along with the 2J definition, which I have discussed in the very first slide, you will definitely get all the marks required for you. With that, I am concluding this video. Thank you so much for watching me. A lot of comments coming in, which gives a lot of motivation to me make more and more videos. Please subscribe my channel if you have not yet subscribed. Please comment good bad things. Suggest me if there is any mistakes happened. I will correct in future videos. Thanks for watching me. Share and comment my videos. With that, I am concluding. All the very best, and thank you so much.